Right. Good morning or good afternoon, depending on where you are located at. Appreciate everybody that's attending today. We've got a pretty good group here, and it looks like there's more people joining as we speak. So we're going to be respectful of your time. We're going to go ahead and get started here. Um, I want to start with some quick introductions here. I'm going to introduce myself. I'm going to introduce my co-host Brett, give you a little background on our firm, and then we'll jump into what we're here to talk about today. So. My name is Landon Long. I'm one of the partners with Evans and Davis. I've been here for over a decade. I too am one that has a young family, so this presentation geared towards those of us that have young kids or minor children is very applicable to me. I've got a 6-year-old Lawson, a 3-year-old London, who's definitely going to be my problem child. For those of you that have more than one, you know that second one is always an issue. And then we just recently had Livy. She's my third. She's about 6 months old and refusing to sleep. So if you see some bags under my eyes or some bloodshot eyes here, don't judge me. I was up all night, but she's the cutest little thing you've ever seen. So I'm blessed and happy to be here. Uh, Brett is my co-host. He has been practicing for 6 years. He holds our licensure in about 9 states. He does not have kids yet, but he does have a golden retriever that is like a baby. Fun fact about Brett, within the last week, he completely uprooted and moved to New York City. So he is living in Manhattan right now and getting adjusted there. But I'm glad he still is able to make this work. And so we're excited to be here. I see, looking at the list of attendees, I see a lot of familiar names. So I know a lot of you are already familiar with our firm and who we are and what we do, but I think it's still good to touch on that for those that may not. We are a law firm that specializes in very few areas, estate planning, trust administration, probate, and business succession planning. We have about 25 attorneys or so, about 60 folks overall. You can see most of our crew right there. That this is all that we do. Talking about people that have young kids, minor children, guardianship, trusts, wills, all the things we're going to talk about today, that is all that we do. I don't do anything else. I don't do criminal law. I don't do family law. If you get arrested, don't call me. We're both going to end up in jail. But when it comes to wills and trusts and things like this is what we do. And so we're excited to share some of this information with you all. A couple quick points here. We are licensed in all 50 states, either directly in-house. I think directly in-house we're at about 45. There are a few states where we have of-counsel relationships, but that was an initiative that we started this year. I mean, we've been gradually working towards it, but we have it complete this year. That way we can serve clients in any state, anywhere in the US and DC, I suppose. Um, we are a little bit of a different law firm in terms of most attorneys that specialize in estate planning are either 1 or 2 person firms, or you've got to go find a large firm that has, 100 lawyers that may have an estate planning division. We kind of slide in between those two, and to our knowledge, we could be wrong, but to our knowledge, we're the largest estate planning firm in the country, which means we have lots and lots of knowledge. Last time we did some calculation, I think we have over 300 years of estate planning experience between all of our attorneys and staff. Um, but it's also not like you're just a number. And so we're really proud of the fact that we are still a small firm, but we have a lot of experience in this area. As I mentioned before, we really only focus on 4 things: estate planning, business planning, trust administration, and probate. So as we're going through this today, I have the Q&A open. Don't I have the chat disabled, so if you have a question or you have a comment, put it in the Q&A. We're happy to answer any questions as it relates to those 4 things. For today's agenda, we're going to try to keep this to about 30 minutes plus a Q&A. That is completely contingent on if I get to talking or not. My joke is always I love a good captive audience, and so we'll see how that goes. But there's going to be a Q&A at the end. Don't wait until the end to ask your questions. Go ahead and put them in the chat. We'll either answer it directly at that moment, or I'll hold it till the end and then we'll go through those. Um, we're going to do a little bit of an estate planning 101, just briefly. I see a lot of the folks on the list here are some of my clients or some of our firm's clients. So you know some of this stuff. We're just going to do a little bit of a highlight, a little bit of a recap so that we're on the same page. Then we're going to really dive in and say, okay, what does that mean for Landon that has a 6-year-old, a 3-year-old, and an infant? What does that mean for somebody that has some teenagers? What are the things that we need to be looking at? And so we're going to go through that as well. And the one thing that I want to start with, because it's really easy to hear the word estate planning and think, well, that's for the Rockefellers and that's for, the ultra high net worth. That's true, but it's also for me. I don't have millions of dollars laying around. But if something happens to me, I've got to have a plan. I've got to make sure that what I'm doing, what I'm creating, and my family is all taken care of. And so I want to start with that in mind. I don't care how much money you have. I don't care how many kids you have. This is something that is probably applicable to every single person. And so we're excited to get into this. That being said, I'm going to turn over to Brett, let him jump in and get started here. And like I said, if you have questions, things pop in your mind, I've got the chat open and I'll be monitoring that as we go through this today. Thank you for being here.
Yeah, thanks, Landon. And full disclosure, like he said, just moved to New York City, spent the last 3 days uh, getting moved in and acclimated into our apartment, and we did it all in the middle of a nor'easter. So if you see any bags under my eyes, please, I will ask you to forgive me, give me a little grace this afternoon as I'm trying to work through it as well.
I'll trade
But
you a
I'm
6-month-old for Nor'easter, Brett.
um, So, like Landon said, we're excited to be here and to be talking with you guys. Um, Whenever we were sitting down thinking about what we wanted to present on for this webinar, uh, you know, we decided that this is a topic that needs to be addressed because, this is one of the most common questions that we receive, and it's when's the right time to start estate planning? And the reality is, the attorney answer is that it depends. Everybody's situation is different, but the correct answer is that it's probably never soon enough to start planning and putting a plan in place to make sure that your family is protected. So what is estate planning? What does that mean? Estate planning is the comprehensive plan that governs your personal and financial affairs. Um, Oftentimes, it can include a revocable trust, and this is the main document that of an estate plan that does a lot of the heavy lifting. Um, it explains who gets what and how assets are received upon your passing. And we'll kind of, as we go through this presentation, we'll work through uh, the nuts and bolts of that and how it works, along with all of the other documents that are included in an estate plan.
I think the way I get that question all the time, and it's like most people don't even know what the heck that means. When I started here 11 years ago, I walked in and didn't even know what that meant. And I think the easiest way to think about it is we all have stuff going on. We may have property, we may have cash in the bank, we may have life insurance policies, we may have investment accounts. We also have kids, we have family dynamics, we have all this stuff going on. And the idea behind an estate plan is let's take all these different components of our world that we are controlling and that we're directing traffic on, and let's push them all together and create something that can direct traffic if I'm not here to do it for myself. If Landon Long is gone tomorrow, there are things that I do that maybe my wife doesn't know how to do. There are things that I want done for my kids that they don't know how to do for themselves. And so, how can I create a plan that says, if I'm not here, this thing is going to take over. This is what's going to take care of my family. This is what's going to take care of my assets. And that can look like a lot of different things to a lot of different people. We have lots of options out there, some good, some bad. But that's what it is figuring out what is the solution that fits you and your family dynamic. The cool thing about what we do is every family is the exact same in that every single family is very different. And so it's kind of like a puzzle. What levers do we need to pull? What things do we need to do to get you in a situation where if you're gone, if you're not here to do it, your family, your kids, your assets are all good to go. They're all taken care of.
So whenever we're talking about putting an estate plan in place, there's really three options that clients that we meet with have at their disposal. One is not having a plan in place at all, leaving your assets up to the discretion of a court to decide where your assets are going after you're gone. Um, Option two is to draft a basic will. Um, a will is a great tool, and Landon and I will never talk anybody out of drafting a will. It does a lot of great things. It allows you to decide where your assets are going upon your passing and who they're going to. Um, the only drawback with a will is it still has to go through a probate process. And we'll get into that as we move through the presentation, what goes into a probate and the disadvantages that can come along with that. Um, but the third option that you have is to put a revocable trust in place or just trust-based planning in general. It's really the best option. And I'd say for a majority of the clients that we meet with, this is what our recommendation is going to be, because it provides the most flexibility for your family as you move forward. It gives you the most amount of control as far as how assets are distributed after you're gone. And, lastly, it's private. It's a private document. It's basically I like to say that it's a basic will on steroids. So it gives you much more discretion as to how assets are distributed, with the added benefit that it's a private document and you don't have to go through court or a lengthy probate process
I
whenever
do a really
whenever you're
cringy
gone.
thing when I give this presentation live, and I ask for a show of hands. I'm like, who has an estate plan? And like two people will raise their hand. The reality is every single one of you has an estate plan already. It's just a matter of, did you get to pick where your stuff goes? Did you get to pick who's in charge of your kids? Or is the state doing that? And if you took some action steps to actually make those decisions for yourself, which is usually a better outcome, where do those decisions live? In something that is going to have to go through a probate process, which Brett will talk about next, or something that is a more efficient, a more protected tool for our kids. Because ultimately, you have an estate plan. It's just our approach is we want it to be one that you created, not one that our friends at the state level has decided works for every family in fill in the blank state, right?
Right.
From that standpoint. So, Brett, why don't you talk to us about probate and what that process looks like?
So this is just a chart of basically laying out the probate process and what it all entails. It's lengthy. It's drawn out. Your executor or your loved ones who are in charge of administering your estate once you're gone have to go through all of these steps and jump through all of these hoops to make sure that your assets that you worked hard for your entire life are distributed to the people that you want them to go to. Unfortunately, they have to go through all of these steps to make sure that that happens. Uh,
Brett, I got a question in the Q&A that I think you can answer real quick.
sure.
It says on average, how often, or sorry, on average, how long does it take to get through probate start to finish?
Best case scenario, and this varies depending on what state you live in. Best case scenario, 6 months. If and that is if everything runs smoothly, there are no conflicts between family members, or if there's a dispute between creditors on if they stake a claim on your assets after you're gone, they have the ability to come to court and say, you know, Landon passed away. He owes me this much money. I'm entitled to that first before anybody else gets a cut of it. So that type of thing happens all of the time. And we run into it with clients, and we see it on a daily basis that, they think that a will is good enough um, to put a plan in place for their family. But whenever something like that happens and people come forward and then the fighting starts, that's whenever the probate can be drug out for much longer. Um, you know, I know that Landon has a story of a friend of his that he was doing, or he was drafting his estate plan, and something was left out of the trust and it ended up triggering a probate. And 3 years down the road, they're still dealing with it. So it happens to everybody. Um, but yeah, best case scenario, 6 months, up to a couple of years.
The topic of this, and we're going to get into this in just a minute, but is young families, young children. If my mom were to pass away today and left me $10,000 or $10 million or whatever it is, and I had to go through this process, I'm probably going to be okay. I don't have to have that money tomorrow. If my wife and I are gone tomorrow, whoever takes our kids, that's a very different situation because my kids need health insurance the next day. They need money for school. They need money for soccer camp. They need all my guardians, grocery bill is going to double, things like that. And I don't have the luxury of time. And so this is something that we want to avoid at all costs if we can for our young families. But that's not the only reason for planning. Brett, tell us just a little bit more about some other potential things that would cause us to want to do a little bit more robust planning here.
Yeah. So the reasons we just stated, avoiding that probate, the cost, and attorney fees. Attorneys like Landon and I make a lot more money on the back end helping you through a probate process rather than being proactive and putting a plan in place beforehand. That's just the way it works. Uh, we also want to avoid those conflicts that I was talking about earlier between family members. Because if you're putting a trust in place, it's a private document. Those who aren't named in your planning don't have a right to see what you've put into your trust. So we're avoiding those conflicts from even happening and delaying the distribution of your assets to your loved ones. Um, Also, like Landon just said, planning for guardianship. That's the most important part, is planning. If we're meeting with young families who have young kids, who's going to be in charge of raising them? Who's going to be in charge of making sure that mom and dad's wishes are carried out and that they're raised in a way that they would have hoped that they would be. So you can address that through this. Also, just making medical decisions. You can uh, name a decision maker to step in and make medical decisions on your behalf, as well as when end of life comes and that decision has to be made whether you want to continue receiving life sustaining treatment or not. That you can take that decision out of your loved one's hands and not put that on them to have to make that decision for you.
I
So
never would have thought in 100 years that I would need to use my wife's medical power of attorney until 7 months ago when we had our third child and her the delivery just went crazy, and all of a sudden I'm surrounded by 10 doctors and my wife is under anesthesia because they had to knock her out, and they're like, what do we do? Here's option A and option B, and I was like, holy cow. Luckily we already have it on file with the hospital, so I could legally make those decisions for her when she couldn't do that for herself. But I mean, in one of the scariest times of my life, I was really glad to have something that I never thought I'd need.
yeah, so I mean, the benefits are endless. The last thing, and we've hit on it a few times before, but more control and distribution of assets. So if we're planning for young kids and the unthinkable happens and mom and dad are gone tomorrow, we need to have a plan in place that says, our kids are not going to receive a big chunk of money as soon as they turn 18, and good luck to you. I hope you make the best decisions possible. This type of planning allows you to put restrictions on distributions. If you want to, you can lay out wishes as far as education go. You can be as specific as you want, but a lot of times we urge our clients to make sure that you're naming the right people to administer your trust once you're gone, so that they can have the flexibility to make sure that your wishes are carried out without being restricted to guidelines, if that makes sense.
Get the right people in the right positions and give them
Right.
a lot of flexibility because we don't know what the world is going to look like when my kids are 10 and 20 and 30.
Absolutely. So we also get, like I said earlier, we get asked when's the right time to start planning, and the answer is as soon as possible while you're young and healthy. It's like Landon said, it's not just for the wealthy or the elderly. It's for anyone who wants to, make things easier on their loved ones and ensure that their wishes are honored. Um, Life can change in an instant, and a well-drafted plan gives you peace of mind that your affairs are in order when that time comes. Um, you know, the this is just a list of different triggering events that uh, we recommend once your plan is put in place. There's times during life that you need to revisit your estate planning to make sure that everything still reflects your wishes from whenever you first put your plan in place to, if there's a death or a birth in the family, if, God forbid somebody falls ill, if there, changes in estate taxes. These are all separate times that you need to give us a call and say, hey, we have decided to pick up and move from Oklahoma to New York, and the estate tax laws are completely different in New York. So we need to sit down and talk about our planning and to make sure that we have everything buttoned up so that nothing unexpected happens whenever we pass away.
So Brett, I got a question here in the Q&A that's a good segue here. It says we just did our wills within the last few years, but I hear you talking about this trust and can I get a little bit more information on that? Why don't we go ahead and jump to that, Brett, and give us kind of a quick understanding and high level view of trust-based estate planning, what that looks like, how does it avoid probate, things like that.
Yeah. So we've been talking most of this webinar about the benefits of a trust and a trust-based plan, and the reality is there are about 8 or 9 other ancillary documents that are included in a comprehensive plan. Um, and a lot of clients are confused whenever we spend all this time talking about the great things that a trust offers and what it can provide for your family. Um, and then the next thing, whenever they sit down to sign their trust into place, they're also signing a will into place as well. And the reality is, the will just serve as a pour over will. It's there as a backup, as a safety net, if there's any assets that aren't properly placed into your trust. When that time comes, then a quick probate is done, and it can ensure that everything's taken care of from there. Also, if you're a business owner, um, also, you know, drawing up a business or a buy-sell agreement for your business. If you share ownership with another person that's outside of your family, and those two agreements, or the buy-sell agreement and your trust, need to work together. So if you were to pass away unexpectedly, ownership in your business is handled in a way that you want it to be. And then we've hit on a few of these before: the financial and medical powers of attorney, as well as HIPAA authorization and a whole suite of other documents. But whenever we're putting a trust in place, um, it it really happens in 2 phases. And phase one is drafting the trust, or we like to say it's like creating a bucket. Uh, you're creating a bucket that you carry with you while you're living and while you have your capacities. And we want to make sure that we put all of your stuff into your bucket. It's called funding the trust. So one of the things that our firm prides ourselves on is um, we we handle all of this for you. So whether it's deeding real estate, retitling bank accounts, handling contingent beneficiaries on retirement accounts or life insurance policies. All of that stuff is what we pride ourselves on, and we've been doing it for over 20 years, and making sure that this is a process that whenever you are signing your trust in place, you don't have to go through all the legwork afterwards to make sure that everything that you own is properly in the name of your trust. Because if there's anything left in your name once you pass away, that's whenever that ugly probate process is going to be triggered, and that's what we want to avoid most.
So we've done kind of an estate planning 101 kind of overview here. Let's talk about why it's important for those of us that have young kids. Um, I always tell people, at the end of the day, I'm here to guide you and give you ideas and suggestions. And very rarely does a client of mine walk in and say, "This is exactly what I want my estate plan to look like." Brett, go back one more slide. Um, Usually they come in and they say, we don't know what we don't know. Um, what works best? And there are some themes that run through every single family, especially those with young kids, and some ideas and some decisions we have to make. Number one is guardianship. Brett and I and our firm could come up with the most tax efficient, most streamlined financial plan or whatever it is. If I'm gone tomorrow, here's how the money side is handled. That could be perfect. But if I don't get this guardianship piece right, none of that matters. Because, when we talk about guardianship, we're talking about if Cassie and Landon are not here to take care of these three hoodlums, who's going to do that? And my world is going to look a lot different than somebody that has older kids. My guardian has a job for the next 18 years. Oh, and by the way, they're going to be changing diapers. It may be different if my kids are 16 and 17. Maybe the decisions and the things that I think through are a little bit different. But for now, I've got to think about who can raise three really young kids. And to be fully transparent, that's the decision that we're probably the least helpful on. It's such a personal thing, but it is our job to say, okay, who's on your short list? And let's talk through why. Why did you say your brother-in-law is? Is it because he's, just a rock star dad? Or is it because him and his spouse as a unit could take care of our kids? And I see that happen all the time where someone's like, oh, well, I'm going to pick my brother. But if you get back there and you dig into it and dig into the why, it's not really because it's the brother. It's because his values or because he's married to somebody that we think as a couple, as a unit, they're the best fit. And so we really need to dive into that and we've got to get that piece right. Um, and I've got my first choice, but I can't force them to take my kids. They could have something going on in their world that prohibits them, or they just say, "Hey, my life is crazy." So we need to have a backup too. And so we spend a lot of our conversation talking about that piece. It's probably the hardest question for most of my young clients, and probably the one where I see the couple disagree the most. But we're here to help you through that. Once we've got that figured out, then we need to talk about the money side of things. And really what we're talking about is how and when can the kids receive assets? At the end of the day, what I'm building and what I'm creating, I want that to go to my kids. I want if we're not here to do fun stuff with them, I want my money to go to help them do fun stuff. I want to provide for college if that's what they want to do. I want to provide for trade school if that's what they want to do. I'm not doing all the things that I'm doing because it's good for my health. I'm doing all this because I want to make sure that my kids are taken care of. And so we need to spend some time talking about that piece. Now, every family's a little bit different. Once we dig in and get to know your kids a little bit, it's going to look a little bit unique. But as I mentioned earlier, my approach is always let's go a little bit more conservative now than we think we need to be. And let's get the right people in the right position. And just as an example, my trust says until my kids are 40, someone else is going to control the financial side of things. Someone else is going to control the money. Why did I pick age 40? I have no idea. In my head, it just makes sense. I think um, you know, a 40-year-old is going to have a little bit of a different worldview than a 25-year-old. And I see that happen a lot where clients are counseled, well, default rules, as Brett said, is 18, but let's make them wait until they're 25 or 30. My concern with that is, did we do math? And not that I'm a math expert, but did we do math? And did we think through this? Because let's say that I've got $1 million worth of life insurance and $1 million of other assets. Or $2 million worth of, let's do $2 million worth of life insurance and $1 million of other assets. I've got three kids. My youngest is 6 months old. If I allocate $1 million to her and my trustee does their job and they invest the money, if they can get a conservative 5% return, Livy's $1 million is going to double two times by the time she's 25. Now the math isn't perfect on that. I'm not a math guy, but that's close enough. which means if I said I'm going to make her wait until 25, I just wrote $1 million, or I'm sorry, I just wrote a $4 million check to a 25-year-old. I see attorneys do this all the time. They say, well, let's do 25% at 25, 25% at 30, 35, 40. I'm okay with that, and that can work in some situations, but let's just do some quick math. Let's make sure that works for our kids. And again, let's err on the side of caution because every 3, 4, 5 years, we're going to update this. I hope to update my estate plan in 20 years because I hope that I'm still here. And I hope that the rules that I put in place now don't make sense in 20 years and I can turn those off and I can give the kids immediate control. But I just don't know that. And I don't know where I'm going to be. But that begs the next question. Well, then who the heck is going to be the trustee? Who the heck is going to manage this money? If you're telling me um, someone's got to be your trustee for 40 years, who do we pick? It's a big decision. In a lot of respects, they've got a job for a lot longer than the guardians do. And so, those are the questions that we have to wrestle with. Is the guardian the same person that holds the money? Do we want to have a split? I have a lot of clients that say, I don't have that perfect person in my circle that I trust giving $1 million to, or $500,000 to, or $10 million to, and saying, go manage this for 40 years. Well, we have some other ideas. We have some other solutions. We work with lots of good professionals that we have lots of solutions, but we've got to get it right. And it, I don't want to come off too strong here, but I think we have a duty to our kids to do this um, from that
Hey,
standpoint. So
Landon, how often do you think that those two, the people that you name, and whether as the trustee or the guardian, are different people? Would you say that's a majority of the time, or how often?
I'd probably say super majority. My guardian, I think, is going to be the best dad to my kids. They're also very responsible and very, I'm not worried about them from a financial standpoint, but I want them focused on one thing, my kids. If I make the joke all the time, I'm like, if you don't have a guardian for your kids and you ask, Landon, can I name you? I'm gonna have an easier time saying yes to that because I can figure out how to be a dad to somebody else's kids. But if you said, Landon, will you be my trustee? I'm going to be like, oh, I don't know about that because nobody's ever handed me money, someone else's money, and said, go manage this for 5, 10, 15, 20 years. And so I would say most of the time it's a different person, but that's not always the case
Yeah.
from that standpoint. But those are probably the three biggest decisions that we have to deal with. We have to get those right. The other thing too, the longer we hold the assets back from the kids, the more they're protected. We get into conversations about protecting them from divorces and creditors and things like that down the road. But we've got to get those three things right. One topic of conversation that's becoming more and more relevant is, well, what if I have teenagers that are getting older? Well, a lot of the same things still apply. We still probably need to have, it's pretty rare that I come across a client that says, my 18-year-old can handle X amount of dollars tomorrow. That's usually not the case. So we still have some of the trust provisions that say, hey, kids, we love you. There's money here if you need it, but you're just not going to get it all at once. You're not going to get it all right now or in the future until you're a lot older. But one thing that's becoming a much, much bigger deal than it has in the past is, well, now my kids are technically adults, but they're still kids. Well, in most states, when your kid turns 18, they are their own person. They are their own adult. And what's happening, especially with respect to HIPAA laws and healthcare laws, is hospitals and doctors are getting really restrictive in terms of what information they can or can't share. I had a client within the last few years. Um, I had a daughter that was at college, and she was involved in a car wreck, and it was pretty rough. She got meta-flighted to a hospital. Well, the roommate kind of picked up on like something's not right here. Like, haven't heard from her, whatever. She calls the parents. Parents are like, no, we haven't heard from her. They're calling around. They can't get a hold of her. Well, I mean, that's where everybody's brain goes, right? Is something bad happened. And so what happened though is the daughter was admitted to the hospital, but because she didn't have any healthcare documents in place or anything like that, she's an adult. the doctors and nurses legally were not allowed to even notify the parents. And so mom and dad are calling, every hospital in the area, and the response they're getting is, we can't even tell you if she's here, much less her condition if she was here. And what happened in that situation is a nurse took the daughter's phone, stepped out in the hallway, found mom on the phone, and called mom and said, "Listen, if you tell anybody that I'm making this phone call, I'm going to lose my job. I'm going to lose my license. But as a mother, you need to get here because your daughter is here and it's not good." And we see that time and time again. And so some things that we need to be considering for our kids that are becoming adults, but they're still kids. The kids probably need to have their own financial power of attorney, their own healthcare documents and things like that. And so we've been doing a lot of that lately, and I thought that was relevant to the conversation today. Um, last slide that I'll touch on, and then I'm going to kick it back over to Brett to wrap us up here. Um, know that a lot of what we're doing here is planning for the future. A lot of what my trust speaks to is education for my kids. And who knows what that's going to look like? Who knows what that's going to cost? But it's going to be expensive. But we spent a lot of time talking about if I'm gone tomorrow, making sure that my trust is set up in a way to provide for my kids' educational needs, housing expenses, making sure that I'm not giving them too much money at one time. Having three kids, I know some of you have more than that. Three kids is a lot. Making sure that we're viewing this appropriately through the right lens, in terms of, is it equal thirds? Or do I have a 12-year-old and an infant? Because the infant's cost of care is going to be a lot higher than the 12-year-old because they're a lot older. Or do we have a special needs beneficiary where we think their cost of care is going to be substantially higher than the other kids? And how do we provide for that in a fair way and in a way that we can change things? And then obviously a lot of estate planning, a lot of trust planning that we've talked about is dealing with the assets. And so in there, we have other things, other assets, 529s, UTMA accounts, things like that that we need to account for to make sure that the trust is set up, the guardians are designated, all the assets are funded appropriately so that if we're gone tomorrow, that's taken care of, and then align it with all the other things that we are doing and planning for. And so it's a big topic. It can be overwhelming, um, but that's what we're here for. Uh, Brett and I have been doing this for a long time. I've seen a lot of things work really well. I've seen a lot of things not work well. And I'm gonna be honest with you. And I'm gonna tell you, hey, now that I know your family dynamic and I know your assets, here's three options. And I have some clients that are like, what about this? And I say, that's a great idea. Or I'll say, well, I've seen that not work, and here's why. Maybe we look at something else, but we're here to um, guide you through that process from that standpoint. So Brett, why don't you tell us a little bit about kind of what we need to be doing, steps we need to be taking right now.
Yeah. So, like I said at the beginning of the webinar, this is a topic that's important to both of us, Landon and I, just because like I said, we come across it all the time. People wanting to know when they should get started, and I hope that we've provided a little bit of clarity for you on that. Just know that there is no perfect time, but the best time that you can start is now. And while you're young and healthy, and you can put a plan in place that will put your mind at ease, that after you're gone, if something happens to you tomorrow, your family is provided for and taken care of. And just know that we're here to help you with that. If you want to reach out to us, we're happy to sit down and talk about all the scenarios that can come into play and what's going to work best for you and your family, because each of our plans are specifically tailored to your family and your family dynamic. So feel free to reach out to us. If there are any questions in the chat,
Yeah, we've got a few
Landon,
here,
we can
Brett. So
we can address those.
I'll softball those over to you. Brett, we got a question that says, I created my estate plan in one state, and I've since moved. Do I need to do anything? What steps I need to take here?
Yeah, so this is very applicable, especially to me, because I have a trust that was put in place while I was still living in Oklahoma, and now that I've moved to New York, I need to sit down and readdress that because each state's laws are different. Um, whether it be the state taxes or marital share funding and that type of thing. Every state operates a little bit differently. So, like we said earlier, that would be a time that you'd want to reach out just to sit down and set up a meeting and we can talk about it and make adjustments as needed.
I'm gonna take this question because it's directed at me, I'm pretty sure. We did our estate plan when we had one kid. Now we have several kids. Do we legally need to update it, or are they just taken care of? And the answer is it totally depends on how your estate plan is drafted. So, um, I have not updated my estate plan since we've had Livy. However, when we did our documents after our second child, um, I've got Lawson and London named, and then I have a provision in there that says, and any future kids that come along after this, they're all treated the same. Now you got to be really careful because sometimes it doesn't say that, and if it doesn't say that, then we could have some major issues. And when life slows down and when I'm sleeping more, my wife and I are going to come in here and redo those that way because I want all my kids named. But also to that point, we're done having kids. I'm not having any more, period. Knocking on wood over here. So on this next iteration, I'm going to say we have three kids, Lawson, London, and Livy. I'm not providing for anybody else. That way, if somebody wants to come in and claim that they're a child of mine that I didn't know about or anything like that, they're intentionally excluded. And so I want to close that door off now when I wanted to leave it open, a few years ago. So um, legally, I don't need to update my estate plan, but emotionally, I do want to name my I want to name Livy in there too, so that if we're gone, um, she sees her name in there as well from that standpoint. So, um, Brett, let's see here. We've answered a few of these already. Um, just touch on it one more time. So we've got our house in our trust, but we think we have a few bank accounts that are not owned by the trust. How big of a problem is that?
Yeah. So, unfortunately, if there are any assets or bank accounts or anything like that that are left in your individual name, once you pass away, that's when that probate's going to be triggered. So we want to make sure that we attack that and you know prep some bank transfer letters to make sure that the name of the trust is uh, is on those accounts rather than in your individual names, just because we want to make sure that we have everything buttoned up when that day comes.
I've got a question about a business going into a trust, and I'm gonna kind of answer this in an indirect way. So, a lot of our clients are small business owners, and oftentimes that is one of the largest pieces of their estate plan. It's a large piece of their net worth, and um, for somebody like me that has young kids, I own a business. I own some rental properties. I have some other things that's going on. And I don't really have a true succession plan. At some point in time, maybe I will. But right now I don't. And my kids are way too young to deal with that. And so the question is kind of about that, like what happens to my businesses and some of these other illiquid assets, if I'm gone tomorrow and my kids aren't ready to take it over, or my kids don't want to. And the reality is it totally depends on what rules and what things you put in your trust. Generally speaking, that's going to be up to the trustee's discretion, and they need to take, if I was advising them, they need to take a cost benefit analysis and say, okay, Landon's gone tomorrow. What do we do with his shares of the law firm? Well, we have a buy sell agreement, so those are going to go back to my other partners. They're going to buy those from my wife or my kids. But what about these other things? What about these rental properties? Um, they should look at that and say, you know, does it make sense for us to manage these properties or should we sell them and invest the assets? And if I don't have a specific provision to do so, that's usually what they do. They say, okay, it costs X to run these properties, it makes Y. What makes the most sense? Now, I do have some clients that are like, okay, I'm fine with that, except for this cabin or this lake property. I want that to be there for my kids when they get old. And when they have kids of their own. And so there's always things that we can do to help with those unique or those special assets outside of just liquidate everything and move on. For some people, that is the best case scenario. And by having those assets in the trust, we can do that the very next day, as opposed to waiting for a year to sell that business or sell that property. But I do have clients that are like, I bought this cabin up in the woods and it may be worth $1 million or it may be worth nothing, but it's important to me that my kids can have that. And so we'll spend some time talking about those unique assets as well, especially businesses, especially properties, things like that. Um, Brett, how does one change a beneficiary of a trust?
There's a couple different ways that you can change a beneficiary of a trust. One of the ways, if it's just a simple addition of an additional beneficiary, you can do a short amendment, and that's just a short document, basically laying out your beneficiaries and adding another one. If you want to make changes to the way that distributions are made, say, um, you have a child that's not making the best financial decisions at the moment, and you want to put more restrictions on them receiving their distribution, then it can be a little bit more complex, and we can kind of walk through those steps with you as to what needs to happen when making those changes to beneficiaries.
Perfect example was this morning. I met with a client who reached out last week and said, I want to make it, I want to make a change of my trustee. Great. Normally we would just use an amendment for that. But then when I sat down with them, they're like, okay, well, the more I thought about it, I want to change this. And I have 5 other changes.
Yeah,
Well, it's going to be easier and cleaner for me. Instead of amending 10 different sections, it's going to be easier for me to do a restatement of that trust, which keeps the name and the date, but
yeah,
we get to start over more or less. It's just it totally depends on kind of what changes we're looking to make there from that standpoint.
yeah.
It is 12:47. So that's about where we wanted to wrap up. I think we've answered almost all the questions that are in the chat, or at least we touched on those. But if there's some that we didn't answer, please shoot us an email or let's set up a time to talk. Um, we really appreciate your time and your attention, and you guys were asking great questions.
Yeah.
So happy to help in any way that we can. But from all of us at Evans and Davis, thank you so much for your time.
Thank you, everybody.